Good morning, good afternoon, good evening, everyone. I hope you all are doing fantastic and are excited as we are for today's insightful session. On behalf of the organizers, IIPLA, I warmly welcome each one of you to this exclusive webinar on IPR valuation, a topic that sits right at the intersection of innovation, law, and business strategy. Before we start, let me ask you a quick question to everyone. Have you ever wondered what is the real worth of an idea? Not just emotionally, but commercially. So, how do you put a value on innovation, creativity, or breakthrough invention? So, these questions are very common to answer, and for this, we have a very fantastic speaker with us. So, who is going to uncover exactly that? And to guide us this fantastic journey, I would like to invite Ms. Isha Sharma as an IP practitioner and founder of her law firm. Ms. Sharma brings with her a wealth of experience across the complete life cycle of intellectual property, from nurturing early stage innovation to handling complex prosecution, opposition, and strategic portfolio management. Her expertise span patent, trademark, design, copyright, and beyond. She has worked closely with individuals, startup, SMEs, and corporate, helping them not just to protect their IP but truly understand its value and leverage it strategically. And today, she is here to simplify, demystify IPR valuation for all of us. So, whether you are an innovator, legal professional, entrepreneur, or simply curious about how idea translate into tangible value, this session is going to be incredibly insightful. Before we begin, just couple of quick housekeeping point for everyone. Please keep your microphones muted throughout the session. You can drop your question in the chat box. We will try to take them during question and answer segment at the end. And most importantly, stay engaged because this is going to be an interactive and knowledge packed session. So, without further delay, I would like to invite Miss Isha Sharma to take the virtual stage and guide us on IPR valuation. Isha, the stage is all yours.
Thank you so much, ma'am. It's certainly my pleasure to share whatever limited knowledge that I've gathered over the years. So I'll be presenting you a little information about the IP valuation, how to go about it, what are the different methods that you can use to conduct the IP valuation, what are the usual forms of IP which are mostly considered as worthy, and then in the end, certain examples like basis on the data, which is available for the access. Basis on that, certain examples of trademark as well as patent valuations that are given to the IP portfolio. We'll share that as well. So just allow me a second to share the presentation and let me know once it is visible to you. I hope the presentation is visible to you.
Yes, Isha, it is visible now.
Okay, great. So as the introduction is already being placed, I'll just skip that. But just to give you a little information about the kind of background that I have. So I come from technology field. After doing masters in biotechnology, I shifted to patents to be more specific. And later on, I realized that for you to be functioning into IP, you would require a law degree as well. So I did an LLB and pursued LLM during COVID time. So luckily, I got that enough time to pursue that. So I've been delivering a lot of sessions on different IP topics. So I've done more than 200 of them till now, and few awards that I've received here and there about IP awareness programs. So moving straight to the topic about IP valuation, we will just try to understand what exactly the term IP valuation means. So as it is self-explanatory, putting a value or putting a monetization figure to any IP form will be considered as an IP valuation. So I believe that most of the audience is from IP domain. So you already know that if we have a product, we have different forms of IP. So for one single product covering different subject matters, like for your brand logo, we will have trademarks. For technology patents, for design, we can register utility patent applications, or we can have a design patents in US, and in India we call it as industrial designs. Then certain IPs which are not properly governed by law, like your trade secrets, which can only be enforced with your contracts, and the technological enforcement. So for one product, whenever we are going for any sort of IP valuation, we would also need to understand that what subject matter are we trying to value, and basis on that, the strategy will change. The scoring mechanisms or the parameters will also change. So before going to the methodology, how we do the IP valuation, let us first try to understand that at what certain scenarios do we require IP valuation? Because most of the time while interacting with a lot of people, they ask this question like, when do we need to have a value to your IP? So see, if there is a company which is going for any merger and acquisitions, or probably going for any round of investments for a case of a startup or an MSME, they would require the value of their IP so that whatever investment rounds that they're pitching to the investors can be structured properly. When there is a merger and acquisition, of course, your IP portfolio also gets acquired, and it is said that roughly around 70 to 75% of technology-based companies' entire valuation is contributed by IP. In the same line, if you're utilizing it for any commercialization, say any franchisee model, licensing model, or you want to do have your IPR pooling mechanisms, you want to go for any joint ventures, during those scenarios, your IP portfolio needs to be valued to derive to a figure. Sometimes in litigation and disputes as well, like either you can already have your IP valuation in place, or sometimes court can also ask you that on what basis are you calculating these damages. So if you want to sue the other party either for the profit or the damages that are being incurred, you would have to have your IP valuation in place to justify the figure that you are asking for. And in certain countries, IP value can also be utilized for collateral purposes. So in China, we know that roughly around 80% of the IP valuation, you can actually ask from the banks, and you can put your IP portfolio as a collateral as well. So that can help you in that regard. Unfortunately, we don't have too much of IP, I would say, collateral being entertained in India. So there are different methods by which you can do IP valuation. So we'll go one by one. We have qualitative method. So qualitative method is usually done by, I would say, IP professionals, because they understand the nitty-gritties of the entire IP cycle. So we'll study that also in detail. So qualitative method basically means putting a value or a figure to the IP, and that figure can be derived by multiple parameters. Qualitative methods, on the other hand, is a combination of, I would say, registered valuers along with the IP professionals, because you need to understand the technology, and also you need to have some kind of a finance or a valuation background to be able to derive to those figures. So there are different methods when it comes to quantitative evaluation. So we have cost-based method, we have a market-based method, and then we have income-based method. We'll study them one by one. So as the qualitative method, I was telling that you put a score to your IP. So say, for example, we have a patent application. In a patent application, what are the, I would say, parameters that we can be considered to put a score to it? So if I have a patent application where I have filed a PCT also, then I have entered into probably say 15 to 20 countries as a national base application also. If my patent application is already being granted, I am maintaining the timeline of all the patent applications that are being filed in all the countries. So automatically it will increase the value of my IP, because the enforceability is in place, the jurisdiction that I'm trying to cover, all of that amounts to the value of my patent application. So in a similar example, like when you try to go and buy a house or probably buy a office for yourself, you look around that whether the hospitals are close by or not, whether the schools are at close proximity or not. Do you have clubhouses? Whether it is a 2 BHK or 3 BHK or a villa. So there are certain factors which contributes to the value of your house itself. So in a similar way, we have certain parameters that can actually define to the IP value and we put a score to it. So as I was saying that if you have larger number of citations or the kind of quality of patent application claims that are being written. So in certain scenarios, there are certain patent applications or other forms of IP which is granted, right? So it might not have gone through a rigorous exercise of opposition proceedings. So it was just granted. But when it comes to enforceability, it's a very, very weak application. Then the value of that particular IP is going to be low because it cannot be enforced. If you have larger number of family members for the similar application, then the enforceability increases. So all those parameters into an IP contributes to the value. So higher the value, the more valuation will you have for your IP. So these exercises are mainly done by the IP professionals. So what are the advantages and drawbacks for this kind of evaluation when we are doing? So more or less, it looks pretty simple, right? So we have that information readily accessible. So if I'm going ahead with a patent which needs to be valued, I will have the access to the application, to the claim, to the inventor, to the deadlines being maintained or not. So the information is quite accessible. But then the valuation will entirely depend upon the quality of information that is readily available. So if certain information is not available, then the value of the IP can be conflicted or can be diluted at a later stage as well. And also the expertise is quite critical here. So if the person who is performing this valuation is not very well versed with the IP strategies and with the IP law as such in general as well, then they will not be able to derive to the exact value as well. Then the other form of method is quantitative methods, where we have cost-based method. That's the first method. So this approach is usually used by, I would say, technologies which are not having any, I would say, future perspective right now. We don't know whether it is going to be big or whether it will be adapted by the market. So we don't know what is going to be the future of this particular IP. It's very nascent, it's very recent. So in that case, we most of the time used a cost-based approach. So cost-based approach basically means that whatever cost has been incurred while creating the IP is going to be the value of the IP, where we will analyze certain costs like historic cost, which basically means the development of an IP. So say, for example, if I'm creating a smartwatch for the first time, the the amount that I've incurred to create this smartwatch will amount to the historic cost, and that cost will contribute to the IP valuation. Then we have replication cost. So in replication cost, we also consider the prototype, the unsuccessful or the failed prototype cost. So if I have to basically the amount of investment which is needed to develop the similar IP in the exact same way is going to be a replication cost. So that is also considered, which is in addition to the cost of your unsuccessful prototypes. In the same way, we also analyze the replacement cost. The only difference between a replication cost and a replacement cost would be that in the replacement cost, we don't analyze the failed prototype cost. So this is one approach. Of course, it comes with their advantage and disadvantage. So the disadvantage, as I would say, the definition itself says that it's not directly proportional. The amount of money that you're spending in creating a product can never be directly proportional to the actual value of the IP. So that is a major hurdle there. Then the only scenario where we use this approach is when your future benefit or future projection is not evident. So in that case, you can directly go ahead with it. And in the cost also, sometimes it becomes extremely difficult to decide which cost to include, which cost to exclude. So that again is a gray mark area while having your cost-based approach. So the cost-based approach says the cost to create an IP is directly proportional to IP value. That is how the method revolves around it. Then another approach is market-based approach. So market-based approach basically means that you already have a IP similar to what you have created into the market, and you are going to do the comparison between the recent IP that is being created and what is existing either by competitors or by collaborators, what is already existing. You can just have a correlation with that, and then you can derive to a value to it. So how you can achieve it? It can either be through auction, so you get to know the price of that particular IP, comparing with the relevant data which is already present into the market, so that can be done. And sometimes certain industry follow a trend of the royalty rate. Like for a pharmaceutical industry, it is going to be a different royalty rate. For automobile industry, it's going to be a different royalty rate. So what you can do is basis on the standard royalty rate according to the industry, that can also help you in the valuation of the IP. So what are the drawbacks? More or less, most of the time, market approach cannot be followed because the data under which we are doing this comparison is not easily accessible. This is a critical financial information, so most of the time it is confidential in nature. You will not be having too much of information regarding the same. So that is the difficulty. Otherwise, it's a very straightforward process. So advantage wise, if you have that information, nothing like it is going to be a very easy process to derive the valuation. So the market-based approach basically means the price of the comparable IP is traded between the parties is equal to the IP value. Just a second. Then we have the the income-based method. So income-based method is usually dependent on the future output of that particular technology. So what we are doing is we are projecting the future and then we are deriving to the current value of that particular IP. Very prominent when it comes to software-based innovations and AI-based innovations. So their income-based approach is usually being followed. So it's done by a DCF method, discounted cash flow methodology, where you are projecting the future value and then according to that deriving the current value. So now, so usually the question arises that because we have these methods in place, but which approach to follow? Like, which is going to be the best method that I can utilize to value my IP? So the answer is that valuation will always be subjective. It is never going to give you the exact value. So if you get the IP valuation done from 5 different registered valuers, everybody will come to a range. Of course, that range will be pretty much similar, but it can never be derived to an exact value. So the best way or the best approach to derive to an IP valuation is to average it out. Try to follow all the methods in place. In some industries, you cannot follow certain methods because of the restrictions that they come with. But if you can average it out, you will be having a tentative valuation that can be placed. Now we'll try to understand certain pointers that we were discussing regarding the putting score of IP. So when it comes to patent application, there are certain critical factors which needs to be considered, like the patent strength and enforceability. How strong the patent application is being written will directly define or increase the IP valuation. The breadth of the claims, as we have already discussed. The legal validity is extremely important. So if I file an application, it's not valid anymore. It got expired. It cannot be under any circumstances revived. So in that case, it has lost its value, right? So then there is no value to that particular IP. In a same way, have you done some kind of analytical researches before proceeding further? Like getting a patent application is one thing, but doing an FTO analysis, trying to understand that what is the gray area, what, how broad the applicability or the enforceability of my patent application is, that will also amount to the increased valuation. Again, the geography and jurisdiction. So the larger number of applications that you file, you try to cover multiple jurisdictions, your IP valuation increases. Then in India, or I would say in certain countries, the ease of litigation is also counted as one of the parameters for calculating the IP valuation, because the enforceability is going to be faster. If you can get an interim injunction in order within few months and within a shorter duration of timeline, and you can actually enforce your application, it automatically adds to the value of your IP. So in trademarks and brands, there are different factors that you need to consider. So of course, apart from the jurisdictions and the validity that is going to be common, we also try to understand that how easily is it acceptable and recognized by the consumer. Because some businesses are doing just B2B business, or some are, if in case you're doing a B2C business, at least in that particular industry, your brand name should be recognized into that business category. So your market share and customer loyalty becomes extremely important. Your number of classes also becomes extremely important, because most of the time, when an IP valuation is being done, not only your core class is important, your complementary classes are also important. So if you have not done it in complementary classes, your enforcement is going to be weak, and that decreases your IP valuation. And whether you're a well-known mark, of course, increases the IP valuation. Whether you have registered it under multiple countries, or maybe at least if not registered, at least you have some kind of a customer base that you can establish. If you can establish your user base, that can also increase the IP value for your brand names or your trademark applications. Then we have certain softwares which are mostly used for doing your IP valuation. So any of these softwares you can use. Uh, I would say that none of the softwares are actually implementing all the strategies in place. So depending on which type of IP would you like to file for, or you want to go ahead with, accordingly you can choose the software. So these are certain recent valuation data that is being made public. So according to the Brand Finance Global 500 report, Jaguar trademark was valued at roughly around $14.4 billion. Apple was valued at roughly around $500 billion, the trademark value. In the same resource, trademark value for the Microsoft Bank was roughly around $450 billion. And when it comes to patent applications for Qualcomm, the licensing. So whenever we are talking about the commercialization can only happen when you have the valuation in IP already being done. So how would you decide the royalty? How would you decide the licensing fee? How would you decide the franchisee fee is going to be directly dependent on your valuation that you're going to achieve. So most of the time, this data, when it comes to the patent valuation, is not readily available. So that can be derived by your commercialization aspects. So for Qualcomm, patent and licensing revenue was roughly around 6.4 billion in financial year 2025. Ericsson was having its patent licensing revenue around $1.3 billion. So now you can understand that what we are talking about when we talk about the IP valuation and the commercialization. So it's really large IP portfolio, and it's not only, I would say, important for the larger entities. Most of the time, what I've seen is that larger entities will get the IP valuation done either during the merger and acquisitions phase or during the IP litigations. For a smaller entity or a mid-scale entity, they would get their IP valuation done when they want to reach out to the investors, or they want to sell off their IP during the commercialization. If they want to transfer the IP during those stages, they usually get this done. So yeah, that's from my side. Now I'll be open to questions. I tried my level best to keep it as short as possible due to the paucity of time.
Thank you. Thank you so much. So I encourage the audience to ask the question to Isha directly, you can unmute yourself and can ask the question, or you can drop your question in the chat bar. Before that, Isha, I have a one quick question. So, can you like walk us through a real scenario where two different valuation methods gave a significantly different result? And how did you decide which one to rely on?
Right. So as during the presentation also, I was saying that out of all these qualitative, quantitative, different types of methods, we need to identify that what are the drawbacks of each and every method. And according to the technology, as I was saying that for software or AI-based innovations, we are actually going ahead with an income-based method. If the technology is not existing before, if it's a first of a lifetime kind of an innovation, then you don't have any background in place where you can do a market-based approach. So then in that case, you would have to go back to the previous method of cost-based approaches. When we're talking about a process-based, I would say, innovation, so if a patent is granted for a process, if it's a process patent, not a product patent is still easy when it comes to the market-based approach. But if it's a process patent, how are you going to do a market-based approach? Because the other market will not kind of disclose the information unless and until they have filed for a patent application. And for trade secrets, which are not disclosed into the public domain and cannot be disclosed into the public domain. So in that case, your which form of method will be applicable? Like you can only derive to a cost-based method because you don't have that information into the market. So you cannot do a market-based approach. Certain times, if you have the access to the licensing agreements, because certain times franchisee and licensing terms are easy to access. If you have that information, you can go ahead with a market-based approach because it will give you most exact results. But when you're not sure about these, if you're not able to do the market-based approach, it's easier to do all of them and then average it out.
Oh, okay. All right. I encourage the audience to put the question in the chat bar instead of like sharing to us in a private place because it's easy for Isha to read it out. So, Isha, I received one question from the AI.
Okay.
If you had to assign a value to an idea today that has no prototype, no revenue, but huge potential, what would be the three factors you'd consider? Do you want me to paste this question in the chat box so that it's easy for you to answer?
If you can, otherwise I got it. Okay, if you
Okay.
have just a
This question is
right.
like
So, because we don't have a prototype, right, and we don't have any information as such, so of course, cost-based method cannot be done. Market-based cannot be done because we don't have that kind of information being available. So, whenever we don't have too much of an information available, but the future projection can be placed, we go ahead with an income-based approach. And of course, you can't put parameters to it because you don't have those patent application being filed, you don't have those jurisdictions being done. So most of time in these case scenarios, your income-based approach method falls most appropriate because there we are projecting the future value and based on that we can do the current value. So income-based approach would be the right one.
okay. Next question also I have pasted in the chat box. What are the key red flags you look for when auditing an IP portfolio before assigning value?
So, see, maintaining the validity is extremely important, right? So, if I'm talking about the scoring mechanism, because the other methods are quite straightforward, that will not depend upon the value that I'm going to assign to the particular IP. But there are certain factors, as I was telling you, that if I'm not maintaining the validity of my trademark application, of my patent application, it will give me a negative value. If I am not bothered enough to put my trademark or a patent application under renewal, it is going to give me a negative value when it comes to IP valuation or the score that I'm going to put it to. So validity is extremely important. If jurisdiction, because certain businesses are domestic in nature, they cannot be placed out of India. So in those regard, we will not put the international parameter in place. So assuming that if in a business is domestic in nature and the international exposure is not required, the red flags would be that it cannot be an application where it is refused. You cannot file for an application if I talk about a trademark into wrong class. You cannot miss the wrong class. You can not only file for a I would say a device mark and skipping the word mark application. Really big, larger giants miss this when it comes to trademark. So if your portfolio is only protecting the logo, it is not protecting the actual word, you understand that how much value are you losing out on justifying that your word can also be protected by the user case scenario, so that you have to prove it into the court. So there are a lot of factors in this way where it challenges the validity altogether of the application. That's the biggest red flag when it comes to IP valuation.
All right. Let me check if I received any question. No. So I'm again like in case if somebody wants to add to uh, the Isha point, they can unmute themselves and can have a direct discussion, or they can
No.
put a question in the chat bar. All right, Isha, I believe we are very good over here. So as we come to an end of this incredibly insightful session, I would like to take a moment to reflect on the valuable knowledge we gained today. So understanding the true value of IP is no longer optional. It's a strategic necessity in today's innovation-driven world. And today's session has truly helped us to appreciate how ideas can be transformed into powerful, measurable asset. A special heartfelt thank you to Miss Isha Sharma for sharing her expertise, practical insight, and real-world perspective on IPR valuation. Your session has not only been informative but also highly thought provoking and enriching for all of us. And I also want to say special thanks to the audience for their active participation, especially to those who have asked the question, the thoughtful question, and the continuous engagement throughout the session. We hope today's webinar has added value to everybody's professional journey and given you a fresh perspective. So before we sign off, I encourage you to stay connected with IIPLA for such knowledge-driven session in the future. Thank you and see you soon again. Thank you,
Thank
Isha.
you so much. My pleasure.